Good afternoon. Thanks for coming, everybody. My name is Peter Neufeld. You may have seen me before at these Lunch and Learn seminars. If you've been to a few in the past, if this is your first one, thanks for joining. Again, my name is Peter Neufeld. I'm a partner at Wagner Sidlofsky LLP. I'm also a co-chair of this Lunch and Learn series on will challenges, along with my colleague, Professor David Friedman. The subtopic that we are speaking about today, I would say, is a rather discrete issue, but it's one that has big implications. It's about how a will challenge is prosecuted procedurally, whether by way of application or by way of action. There was a great paper that was prepared in advance of today's topic or seminar, and a link to that article can be found in the Zoom chat. I'll have Maddie add that now. As always, a few housekeeping notes. Please make sure that your microphones are muted at all times, unless, of course, you're asking a question to one of the panelists. And then once you're done asking that question at the end, I would just ask that you put yourself back on mute. Please also note, as I indicated before, the seminar is being recorded. We have two presenters today. Herschel Sahian is a partner at Wagner Sidlofsky, where he practices commercial litigation and estate litigation. Herschel is also a leading practitioner in professional liability and has a long history of insurance defense work. He'll be joined by Brendan Donovan, who is a partner at Donovan Kochman, where he practices estate and commercial litigation. Brendan is also a prolific writer in the area of estates law, and he's a frequent contributor to continuing professional development programs such as this one. So thank you both for joining today. A big thanks to our sponsors, as usual, the B'nai B'rith, of course, Concentra Trust, Scotia Wealth Management, Torkin Mains, TD, as well as BMO Trusts and Estates. This event and this whole series is complimentary because of them. If you've enjoyed our seminar to date, if you really like today's presentation, we ask that you consider making a donation to the B'nai B'rith Canada Food Program. If you haven't already, the link for that will also be in the chat. Please note that the certificate of attendance for this matter to confirm your CPD hours will also be included in the chat. So make sure you download that before you leave today. Okay, that's my spiel for now. I want to start off with the seminar. I believe Herschel Sahian is going to start us off. So take it away, Herschel.
Thank you, Peter. First of all, good afternoon, everyone. It's a pleasure to be here. Thank you to all of our sponsors. And on behalf of Brendan and myself, thank you for everyone for attending this afternoon. In Ontario, as I'm certain each and every one of you knows, the court proceedings are governed by the rules of civil procedure. The rules are enacted under the Courts of Justice Act. Now, the court of proceedings are either an action or an application. Both proceedings are adjudicated and eventually are subject to judicial disposition. The process of each, however, is different. So, for instance, an action is adjudicated by a trial with witnesses testifying and providing oral evidence. An application, on the other hand, is summarily adjudicated by a judge at a, in quotes, paper trial. So there are no live witnesses, no live testimony. The evidence is often by affidavit alone. Focusing on an action, let's start off with the rules. Rule 14.02 of the Rules of Civil Procedure states that every proceeding in the court shall be by action, except where a statute or these rules provide otherwise. In other words, the default proceedings in Ontario are an action. As the default proceedings, an action is commenced by a statement of claim. For your reference, you'll see these in the paper. We have linked Form 14A for you. The action may be prosecuted under the ordinary or the simplified procedure. Simplified procedure, as you may know, has a monetary jurisdiction of up to $200,000. In an action, the most common steps are the issuing of the statement of claim, the service of the statement of claim, then in turn the service of a statement of defense, the service by both parties, or more properly all parties, of affidavits of documents, and then you get into the discovery. The discovery starts off with a discovery plan pursuant to Rule 29.1. Then there's the conduct of the examinations for discovery. Subsequently, there's a mediation. As you know, in Toronto, Ottawa, and Windsor, mediation is mandatory. Otherwise, it is not. Subsequently, you set the action down for trial, you attend a pretrial conference, and then you attend the trial itself. Conversely, an application is commenced by a notice of application, a number of forms, 14E, 68A, 73A. You can look them up in paper. As of January 1, 2022, many of you will know that there are a number of changes that were made to, among others, Rule 74, in an effort to streamline the probate process and align the forms with, among others, the Succession Law Reform Act. So you should be a little careful of that, specifically of sections 15, 16, 17, and 43. In any event, the application itself is, as we said previously, if the action is the default proceeding, the application is the exception. Other than where specifically required, an application may be commenced according to Rule 1405, where it is unlikely that there will be any material facts in dispute requiring a trial. We caution against this quote unquote catch-all provision of Rule 14 because it's still subject to judicial scrutiny. And in some cases, the courts have deemed the precondition of having material facts in dispute to dictate that an application should be converted to an action, which we will deal later on today. In the application, contrary to the action, the common steps include the following: issuing the notice of application, serving the application record, which includes not only the notice, but also the supporting affidavit, key difference in comparison with an action. Then there's the service of the notice of appearance. A motion for directions often follows. It seeks an order including a timetable, the next steps in the proceedings, as well as ancillary orders for productions, etc. Subsequently, there's the service of the responding record, service if necessary for cross applications. The cross examinations often follow, and they are limited to the examinations on the affidavits that have been served. Subsequently, there's often the attendance at the mediation, as we've discussed under Rule 75. Mediation is mandatory in Toronto, Ottawa, and Windsor. Then we have the service of notice of experts, then the pretrial hearing, and the hearing of the application. Today, we highlight Rules 14, 74, and 75, obviously in the context of the estates. So in the context of estates litigation, and more specifically will challenges, Rules 14, 74, and 75 govern. Specifically, Rule 74 addresses non-contentious proceedings in small estates, which is often 150,000 or less. And conversely, Rule 75 addresses the more contentious estates. Rule 14.05(3) and subsections A to D specifically deal with the estates. De facto, these subsections of Rule 14 dictate that most estate litigation are to commence by way of application as opposed to action. So most probate matters, therefore, are commenced by way of application. Often, as a part of an application, the parties rely on Rule 7506, subsection 1, which states that any person who appears to have a financial interest in an estate may apply for directions or move for directions in another proceeding under this rule as the proceeding for bringing any matter before the court. The rule itself empowers the court to direct many things, including the actual issues to be decided, who the parties are, who is to be served, the procedures for bringing further matters in the court, and whether or not there's a need to file a statement of claim, which de facto would be the conversion of the application into an action. Now, what our topic today may be a bit misleading. To some extent, it outlines that the options of a party is to either commence an application or to commence an action. It's not, however, true that it's an either-or decision. There are limited circumstances where both a statement of claim and a notice of application may be filed and served simultaneously and not be deemed to be an abusive process due to the multiplicity of proceedings. Some of these circumstances are outlined in Rule 7508, such as a notice of contestation of a claim. But there are others where there are either derivative actions or ancillary actions whereby a beneficiary may attempt to actually bring a cause of action against a non-party to the application or and yes, to an action against a non-party on behalf of the estate de facto. So that was a bit confusing, but simply to say from a procedural standpoint, there are opportunities to bring both an action and an application at the same time. Now, when is it an either or? Those usually are outlined in statutes beyond Rules 14, 74, and 75. So, for instance, the Estates Act authorizes a party with an interest in the property of the deceased to bring an application. The Family Law Act authorizes a party to commence an application for equalization of net family property against an estate. And the Succession Law Reform Act authorizes a party to commence an application for support. Rule 74 authorizes a party to apply for a certificate of appointment of estate trustee, again, application. And similarly, Rule 74 authorizes the estate trustee to apply to pass her accounts. Now, in determining at that time whether to commence an action or application beyond whether it is required by statute or the rules, a party ought to consider, among others, the complexity of the facts, the number of facts in dispute, whether there are major credibility issues, and whether there are allegations of fraud, bad faith, etc., including claims for punitive damages. The reason for doing so is that an application is limited to de facto a summary proceeding. In other words, the adjudication of the application is based on the paper record. It's adjudicated by judge alone. There is no jury. There, therefore, is limited benefit of documentary discovery. and consequently, the proceeding itself can be described as quicker, more streamlined, often less expensive than an action. In contrast, an action is broader in its discovery process and the scope of the trial itself. It can be adjudicated by a judge or jury, although rare. If relevant, the motion for summary judgment is available in an action, and the action itself can address more procedural and substantial issues in comparison with an application. Again, a good example is damages, punitive damages, specifically fraud, etc. So the primary differences between the action and the application are in the discovery scope as well as the trial. In an action, a party may serve a demand for particulars under Rule 2510. If you are involved in an action, I strongly suggest looking at the merits of demands for particulars. They truncate the proceedings, they assist with replies, and they subsequently assist in the discovery. And that is a unique feature of the application compared to the action in comparison with the application. A party also in an action is obliged to disclose all relevant documents in her possession, power, or control, unless privilege attaches. That's Rule 30.02. That's very broad compared to an application. At trial, the parties and the witnesses are examined orally. Hearsay evidence is not admissible. A party may read into evidence previously obtained examination for discovery, evidence of an adverse party. These broader discovery rights therefore convert into an opportunity to raise and adjudicate more issues at trial. In an application, in contrast, the cross-examination is framed by the affidavits, regardless of the contents or the allegations of the application. At the hearing, limited hearsay may be permitted due to the affidavit evidence, so long as it's not on a contentious issue and the affidavit references the source of the knowledge, information, or belief. In addition to the procedural differences, there are also practical differences. In an action, the pleadings frame the claim. Among others, the action affords opportunities to advance a number of claims for damages and, as previously referenced, punitive damages. In the paper, you'll see we reference a number of cases, including Walling, where Justice Pierce found that the estate trustee failed to pass accounts, distribute the proceeds, and exhibited a pattern of non-compliance with court orders. The plaintiffs claimed $50,000 in punitive damages. The court, in an unusual move, awarded $100,000 for punitive damages at trial. Of course, there are also similarities beyond the differences. In both, a solicitor may be required to disclose a will of a deceased pursuant to the will exception. You can look up the number of cases, including Hope and Martin. Now we'll move into the conversion of an application into action. The reason being is we've set the stage that the majority of estate litigation is commenced by way of application pursuant to rules, again, 14, 74, and 75. The hearing, however, of the application may be either by way of hearing or, again, conversion into an application, whereby conversion into the action, and the action, therefore, is heard by way of trial. To assist in that, I'll pass it on to Brendan.
Thank you. Thank you. That was great, Herschel. It's funny. When I was listening to you speak about it, it reminds me that although this is sort of a discrete issue, this is something that we have to deal with in practice all the time. And these questions about, how to commence and what the advantages are for proceeding by way of application or action, there are things that we think about and talk about a lot. And so although it is a discrete issue, it's a very common issue. And it often comes up where you have these ancillary proceedings that are happening at the same time. So let's say you have a will challenge, but there's also a passing of accounts application, and there's also a dependent support claim, and there's also a creditor claim. And you've got these different proceedings that are all related, and they've been commenced in different ways, and you have to decide how you're going to consolidate these, when you're going to consolidate them, and whether or not you're going to convert any of the applications into actions. And so, as I'm talking now about conversion, I think it's useful to keep in mind that you have these different highways, right? Herschel has described what proceeding by way of action is like. He's just described the discovery process. He's described all the options that are available to you. He's described what that looks like in the road to trial. And then there's also the application procedure, which has its own features. It tends to be very front-end heavy in terms of the affidavit drafting and so on. They're not the same disclosure obligations. And that road that takes you to the hearing of an application on a paper record. So between these two highways, you should consider that there are a number of sort of on-ramps and off-ramps. So you could, at a certain point, convert an application into an action, but there's no rule that says when you're going to do it. So it could be that you're faced with a case where you have already conducted cross-examinations on the affidavits, and at that point, there's a suggestion that maybe we should be doing pleadings, maybe we should be converting into an action. And so these things come up in practice, and we do need to think about them. So why don't I talk a little bit about those on-ramps and off-ramps? There are a number of them in the rules. They're summarized in the paper. One of them is 3810, which deals with the things that a court can do on the disposition of an application. And under subrule 1, sub B, it says that the court can order that the whole application or any issue proceed to trial and give such directions as are just. And we see this sometimes on a hearing of an application where the court will deal with a certain number of issues and then define some other issues that are to go to trial. And so there is that off-ramp where you're in an application, and then at the hearing, certain issues get hived off and turned into an action. And then there's a trial of an issue where a trial of an issue in the application is directed. The order directing the trial may provide that the proceeding be treated as an action in respect to the issue to be tried, subject to any directions in the order, and shall provide that the application be adjourned to be disposed of by the trial judge. So that's under 3810. There is a similar piece of wording under 37.13 sub 2 sub B, which is essentially the same thing for motions. But those two rules are not very commonly used in estate litigation. In estate litigation, it's more likely that you're going to be looking at the off-ramp that's contained in 75.06 sub 3. Of course, 75.06 sub 3 governs what can happen on an application or motion for directions. And in estate litigation, it's very common for the applicant to bring an application for directions. You need to get all those ancillary orders relating to production from non-parties. You need to get medical records. You need to get bank statements. You need to get different types of orders that you wouldn't typically get just commencing an action. If you have an action, you serve the statement of claim, you get an affidavit of documents. You're going to have to take other steps if you want to get documents from non-parties. So when you're commencing by application, you've got your application for directions, and then 75.06 sub 3 says that a judge can do certain things for you. Under sub A, it's the judge can set out the issues to be decided. Under sub B, the judge can determine who are the parties, who is the plaintiff and defendant, and who is submitting rights to court. Submitting rights to court is kind of a unique feature in applications where a person, often a beneficiary, can say, I'm not taking a position. I'm submitting my rights to court. I'd like to receive notice of certain further steps, but I'm not going to be either a plaintiff or a defendant. Under 75.06, because the judge does have this power to say who's going to be the plaintiff and who's going to be the defendant, the judge can also direct that the plaintiff serve and file a statement of claim under Form 75.7. Now, understand, this is different from a normal statement of claim. There's a separate form. It's called Statement of Claim Pursuant to Order Giving Directions, and you serve and file that statement of claim. And once you've done that, the procedure under Rule 75.07 kicks in, which looks very much like what you would have in an action. It says that a defendant is to file a statement of defense or a statement of defense and counterclaim or a statement of submission of rights to court. And then there's an opportunity for a reply and defense to counterclaim. And so you basically take this off ramp and it turns it from an application into an action. But here's the big question, and Herschel spoke quite a bit about this. Why do you convert your application into an action? Why would you want to do that? Why would you want to take these additional steps? And you've already put in your application and your client's affidavit in support of the application, or you filed a responding application record, you put in your client's responding affidavit. Why at that point do you say, okay, let's also do a statement of claim and a statement of defense and a statement of counterclaim? Why do we graft all of that action onto this existing application? And the answer is also found in what Herschel was describing, which is that sometimes you want that other road. Sometimes you want to have all the things that you get out of proceeding by way of action. And in particular, sometimes you want a trial rather than just a hearing. So the test that a court uses when deciding whether to convert an application into an action is basically the same analysis that you ought to undertake when deciding whether you want to convert from an application into an action. Now, we have some cases that are referenced in the paper on this. In particular, there's a case called Krasuski and City Optical, which is a great decision by Mr. Justice Firestone. It's very useful. He summarizes the approach. There's more language in the paper that you can look at, but basically, as Herschel alluded to, you need to ask whether or not there are going to be issues of credibility. If someone's credibility is an issue, then a judge is going to be very unlikely to want to decide it on a paper record without having the opportunity to sit there, look at the person, and decide whether or not they think, viva voce evidence, live cross-examinations, a judge is going to want to be able to make that determination as to credibility. Another consideration is whether there are really material facts in dispute, not just sort of ancillary facts that may or may not be that relevant, but real hard facts that are in dispute. Are there complex issues requiring expert evidence or the weighing of evidence? Is there a need for pleadings, as in to clarify the claims and the possible defenses? And then this last one is the importance and impact of the application and of the relief sought. The suggestion being that if it's very important, maybe we should have a trial. As if there's a lot of money on the line, maybe the parties should be going through this more comprehensive process rather than the relatively summary process of an application. So, for example, let's say that you have a passing of accounts and it's contested, and you've got there's an objection to compensation. Maybe you can proceed by way of application. You commence the application to pass accounts. There's an objection. They say your compensation's too high. The trustee didn't really do that much. He went to the bank a couple of times. And so maybe you take that to a judge on hearing of an application. You go through the accounts, you make the arguments, you cite some case law, and then the judge makes a decision. But on the other hand, if you have the same contested passing of accounts, and there is an allegation that the trustee stole a bunch of, there's real allegations here of dishonesty, of breach of fiduciary duty. Those types of things probably ought to be heard by way of trial, because there are going to need to be, there's serious allegations, there's serious material facts an issue, and a judge is probably going to want to have viva voce evidence and cross-examinations live at a trial. So what does this mean for will challenges? Because this seminar is apparently only about will challenges. So some people will tell you that it is impossible to adjudicate a will challenge on a paper record. You need a live trial. And the reasoning for that is pretty clear. How do you actually set aside a will? The common grounds for doing it are testamentary incapacity and undue influence. Testamentary incapacity incapacity is a question of fact. It's a very difficult fact. A judge is probably going to want to hear viva voce evidence and maybe even expert evidence on the subject, which lends itself to a trial. And of course, the other basis to set aside a will, undue influence, that's the kind of thing where a judge is going to want to see the person who's being accused of undue influence, and is going to want to see some live evidence. So we actually see this all the time with lawyers who try to bring summary judgment motions in will challenges. You see these cases. There's one quoted in the paper. It's Koster and Koster, which is a 2018 decision. And the court refuses to grant summary judgment. And this is what the court writes. In this case, the evidence of the objectors is both material and conflicting with the evidence provided by the respondent, including that of her witnesses. In my view, it's not appropriate to grant summary judgment on the face of this conflicting written evidence. In order for me to make the required findings of fact, this is the judge saying, in order for me to make the required findings of fact, it's necessary to conduct the required assessment of the credibility and reliability of all the named witnesses and parties. In that regard, it's necessary to hear oral evidence of the parties and the witnesses with the benefit of their evidence after cross-examinations. Now, I know that under the expanded powers of a summary judgment motion, there is the ability for a judge to order limited oral examinations, but in this case, the judge said, no, you need to have a trial, and so it is often, in my mind, a long shot to say that a judge is going to decide this will challenge on a written record. Most will challenges are going to need to proceed to a trial. Now, that's not to say that no will challenges ever get decided on a written record. There's a recent case called Denunzio that actually went to the Court of Appeal later. It's cited in the paper. And that case was a full day hearing on a written record. And apparently counsel agreed to this. They agreed to this procedure. It was going to be on a written record. And the judge held them to that. We will decide this on a written record. Now, query, for strategic reasons, there's always, cost is always a concern. But should you, as a lawyer challenging a will, agree to a trial on a written record as in an application hearing, and there could be some challenges, I would say, to being in that position where you're having to prove undue influence or prove incapacity just on a written record. So back to the subject of conversion. In the paper, we draw attention to this interesting decision that you can sometimes make under Rule 75.06 sub 3, which is that, okay, so the judge has these powers on an application for direction. The judge can say what the issues to be tried are. The judge can say who's going to be the plaintiff and who's going to be the defendant. And the judge can say that the plaintiff has to file a statement of claim pursuant to order giving directions. Oftentimes, in practice, counsel will say, we don't need the additional pleadings. We're happy to just have the order set out what the issues to be tried are. So in other words, you'll have something like the applicant affirms and the respondent denies that the last will and testament of the deceased dated such and such date is valid or is invalid and of no force and effect. And sometimes the issues to be tried are just specified like that, and you have to work really hard on your order giving directions to make sure that you have everything spelled out. Sometimes, as counsel, you will decide, okay, we're not going to do a statement of claim pursuant to order giving directions. We'll just have the issues to be tried laid out in this order giving directions, and this is a one manner of reducing the costs. And sometimes it makes sense. Sometimes it doesn't. Just because you can do something, just because you can cut a corner, doesn't mean that you should. It might be that you would far rather have that statement of claim because you want to really particularize what it is that you're claiming, or you want the other side to file a statement of claim so that you can see in full particulars, right? Exactly who do you say undue influenced this person? At what time? When? Like, you want that particularity, and sometimes you also, as you know, if you want certain defenses, maybe you want to put in latches or limitations or something like that. Maybe there is a benefit to having clear pleadings, and maybe there are other benefits as well. having the statement of claim and then the statement of defense put in. So ask yourself, when you are making these decisions around conversion, when to convert, how to convert, and whether or not you're consolidating with other related proceedings. Decide what is going to be best. Decide what makes the most sense for your client and for this particular case, and then make a decision. And you might have to fight with counsel on that decision. But this is what's so interesting about being an estate litigator is you have all these different possible tools at your disposal. You have options for how to move things forward. And what you need to do is you need to consider those different tools, those different options, and decide which ones are going to work. So that's it. That's all I have to say about conversion. I mean, we could talk more. I mean, Herschel and I have had some interesting discussions, but that's the presentation part anyway.
Oh, that was great. Thank you both for that presentation. I think what I got from both of you was really a lot of this, the decision whether to convert or not. There's a big risk of wasting money in the end from the way I see it is that, and I've had this experience before too, where I do what I think is a pretty darn good affidavit, supporting the validity of a will. And, the opposing counsel probably has the right idea saying that this is going to get converted into an action anyway. So I'm not going to have as in-depth of an affidavit that I did. And that may be, that may be the right approach if you think it's going to get converted anyway, because you're going to charge your client maybe half as much by doing a more streamlined affidavit. And then I also think about, well, if your affidavit's twice as long, more in depth, then you kind of open your client up to the risk of more potential inconsistencies when they are being, examined as a witness at trial. So do you think, given that it makes sense to really try and figure out this conversion issue as soon as the first appearance when you're trying to get an order for directions done? That's kind of the approach I think is let's figure out soon whether we need to convert this. Because if so, then it's going to impact what my responding or moving affidavit is going to look like. And it's going to impact, whether we do cross-examinations or just proceed to examinations for discovery or have an order giving directions saying it's going to be both a cross-examination and an examination for discovery. I don't know if you have any thoughts on that. It's less of a question, more of a comment.
I'm happy to take that one.
Yeah. Go ahead.
Okay, so something that I didn't talk about in my little presentation is that there's also the possibility of a hybrid trial, which is sort of a hybrid between these two highways, where you have evidence in chief go in by way of affidavit, and then time limited cross examination is usually the way it's set up. I mean, there are different ways of creating a hybrid trial, but if you're doing a hybrid trial, sometimes the court orders that trial affidavits be put in. And when that happens, you might end up having to pay for 3 hurdles. There's the application where your client files an affidavit and attaches all the documents that they say are relevant. And then maybe it gets converted into an action. So you have to do pleadings. And maybe you also do an affidavit of documents as part of that action. And then you have to do another affidavit for the hybrid trial. So yes, there are ways that this thing can become extremely costly because of all these options being sort of like layered sequentially over each other. I think that sometimes you can save yourself a lot of costs. I'm agreeing with you here. You can save yourself a lot of costs if you can have that conversation with counsel at the outset to say, I really think that this is going to proceed to trial anyways. Or, there's that other proceeding. They're going to get consolidated. It's all the same facts. They're going to get consolidated. So can we agree to just do one set of just global examinations as opposed to having, these are examinations, cross-examinations on these affidavits, and then examinations for discovery later. I mean, can we agree to have everything done at the same time? And there are a lot of opportunities for efficiencies if you can have those conversations with counsel early. Unfortunately, early on in the litigation, you don't have all the facts, you don't know everything, you haven't seen all the documents, and you might be dealing with an incredibly unreasonable person on the other side.
So speaking of unreasonable people, because he's really referencing me, here are my kind of comments, which respectfully are less optimistic. So number one, is an unreasonable litigator, I'm probably not going to have those in-depth discussions with counsel at a very early stage because of many reasons, including just wanting to be difficult. But more practically, I think there are at least three things that we have to consider. One, under the application and the rules that govern the application, it's generally easier to get productions than under an action that you have to normally bring motions, etc. And because the production obligations are broader, you normally end up spending more time and therefore more money on compelling the other side to make more fulsome production. So my instinct would be that keep the application going for the production stage because it's cheaper and faster and the court will help you out. Number two, practically speaking, respectfully, when you make the comment, Peter, you're forgetting one essential party. So you mentioned the applicant, you mentioned the respondent. The party we're missing is the judge. And of course, the judge may have their own opinion as to what should happen. And obviously, if it's case managed or there are case conferences, you're going to have that input from the judge earlier on. But you may not be at a point where you can convince or persuade the judge that you're at that point where the application ought to be converted into an application. So we all know that judges have their own temperament. I just think practically speaking, we have to remember that a judge is going to be a part of that conversation and at the end of the day, decide when the conversion is actually going to occur. Lastly, I just want to augment Brendan's position about the hybrid trial. So under Rule 76, which is not as common in estate litigation, you do have a summary trial. I find that most judges, again, bringing back the judge as the third part of the tripartite relationship, are not as keen on that mechanism, even though it's available. It's almost exactly what Brendan was saying, that there are expanded powers that the court are offered for summary judgment motions, for that the new section 21, is it 21.1? But in any event, the point of it is that the judge is going to dictate the final outline as to how the trial is going to be conducted, and that's the key. I just don't find that most judges are keen to convert the application into an action in an early stage.
Great, thank you both. Excellent.
I have a question. So if the lawyer who drafted the will is going to be examined, is the process different for them if they're being examined in an action versus application? And if so, what do they need to know?
I guess I'll take that one. I apologize. I'm not sure if I understood if as the lawyer as a party or a non-party. Just jumping into it, if the lawyer is a party, meaning, as Brendan said, there is a companion action, ancillary or derivative, it doesn't really matter, and the lawyer is a party, then under an action, which is often the case in a solicitor negligence claim, there's going to be fulsome discovery of the drafting solicitor. As a non-party in both an application and an action, you're going to have to bring a motion for leave under Rule 31.1. And there are a number of steps that you're going to have to overcome. Primarily, the first one is that you're going to have to show that the production of the file and the evidence from the lawyer are relevant to the issues. And then you're going to have to, if you pass that, you're going to have to show a number of other considerations. I've had time now to open it up. 31.10 subsection 1. So there are at least 3 more provisions. The moving party must show that it has been unable to obtain the information from other persons whom the moving party is entitled to examine for discovery, or from the person the party seeks to examine. Next is, it would be unfair to request the moving party to proceed to trial without having the opportunity of examining the person. And next, the examination will not either unduly delay the commencement of the trial or the action, entail unreasonable expense or other parties, and result in unfairness to the person the moving party seeks to examine. It's a relatively robust test that you have to meet under the rules. As everyone knows, LawPro should be notified. LawPro normally appoints a counsel, and normally, with the exception of production of the will, takes a relatively aggressive stance on not having examinations of the lawyer as a non-party, unless, again, absolutely necessary.
I have a question I could hop in with. This one's, again, you mentioned LawPro about professional liability. So I'm just wondering if an action with a new court file number is commenced after a conversion from an application. Does the will drafting solicitor need to report this new claim to LawPro?
I guess I'll follow up on that one. If I understood correctly, you have a number of situations that could arise, as Brendan discussed previously, because the conversion could be with pleading. It could be that there is no other pleading, if it's a court order simply directing what issues are to be adjudicated at the trial. If there's a new court file number, I'm not sure why there would be a brand new one. Normally, if there's a consolidation, at least one would be preserved. But regardless, at that point, you should absolutely report it to LawPro to keep LawPro apprised. So if I could step one step kind of before that, the moment you get any notice for production of a will, for attendance at an examination, you should report it to LawPro. You don't want to compromise your coverage that is available under your mandatory insurance. So that's number one. Just report it, even if it's out of an abundance of caution. But number two, presumably, especially if you have been discovered, then LawPro already has the file open. There is a lawyer, and the lawyer would have fielded any orders coming from the court with regard to the conversion of the application into an action. So the lawyer would probably deal with it. If for whatever reason the file was held in abeyance, etc., any new pleadings should absolutely be forwarded to LawPro so LawPro can assess whether or not it's still the same claim, whether it's a new claim, and whether or not your discovery is required or your attendance in person is required.
May I follow up with a question in that regard? I have heard that some counsel, as a matter of course, will add the drafting solicitor as a party. How common is that? And is it prudent to do so?
Brendan, you want to start that one off?
I can certainly start it off. I mean, I don't know that I can tell you how common it is. I know that it is a practice. I like to think that most lawyers don't immediately sue drafting solicitors just because there is a will challenge. It's, you know, it's not clear to me that the drafting solicitor will, or that there is a case against a drafting solicitor just because there's a will challenge. When you say how prudent is it to do so, I think that it depends on the facts. Really, it depends on what you are looking to accomplish. I don't think that's so. This opens up a different question, which is, okay, if you're bringing an application for directions to challenge the will, but you also intend to sue the solicitor for solicitor's negligence, are you commencing an action against the solicitor at the same time, and then are you going to consolidate them at a certain point? So it's I don't think that it is proper to immediately sue the solicitor in every case. In some cases, it might be warranted, but that is a decision to be made by the lawyer in view of, you know, having all the facts and understanding the objective of the client as well.
If then you are close to the end of a limitation period, you're bumping up against the limitation date. You're alleging that the deceased did not have capacity and was subject to undue influence. Would that be an appropriate time to add the drafting solicitor? Because really you're saying that he should have recognized what you're claiming right then.
Well, first of all, don't miss limitation periods. I think we can all agree on that. But I don't know enough about the facts in this particular situation to know whether the claim against the solicitor is warranted. But oftentimes in a situation like that, where I don't want to miss a limitation period, I can try to negotiate some form of tolling agreement. Sometimes LawPro will do that. Sometimes LawPro will not, and they will say, issue your claim. In which case you have to issue the claim. You can always give a waiver of defense. You can issue a claim and you can say, we're not asking for defense from you right now. I think your key objective has to be not to miss a limitation period. I'm sure Herschel will say the same thing, but I don't know if Herschel, you have any other thoughts?
Well, working my way backwards, I'm not a fan of tolling agreements for many reasons. So under somewhat the broad circumstances that you described, Paul, I would probably issue the claim. I may wait about service and have a discussion with counsel. I may just serve it, and as Brendan said, waive defense, because one of the issues kind of before you raise the limitation period issue is costs. So I wouldn't be necessarily a fan of just commencing an action against the drafting solicitor for the fun of it, because I could be nicked with costs, or more properly my client. So you normally only know if you have a case against the solicitor, after you get the solicitor's file, because if you don't have the solicitor's file, you're flying in the dark, and B, kind of any extrinsic evidence, especially from your own client. But I guess the two main points are, one, I can't speak about how common it is or isn't. Practices also evolve. I used to represent lawyers for many years through Law Pro, but I don't know if it's changed over the last few years. But again, the two main points are, I don't think that you should automatically add a drafting solicitor, because you're complicating your own proceeding. You're going to have Law Pro, which is going to be somewhat aggressive. You're going to have productions, etc., and fights over orders. So you're increasing the cost to your own client, and you're exposing them to costs if they're unsuccessful. If there's a limitation period, I do strongly encourage commencing an action, putting it in your back pocket, engaging in a conversation, maybe serving it, engaging in a further conversation. You bought yourself minimum 6 months, and that should be enough time to better assess your case.
Thank you so much for those answers. That's been very useful.
Pleasure.
If anyone else has any other questions, feel free to ask them now.
I'd like to ask a question. I was going to ask Herschel why he doesn't like tolling agreements.
Lots of that's complicated. First of all, they're usually complicated and involve a lot of reading, and that's against my religion. So I got to convert, excuse the pun about all of our conversion discussion. But to be blunt, as a Law Pro counsel, I often was allergic to them because their plaintiffs' counsel obviously are attempting to have a very broad agreement, right? Because the broader, the better if you're the plaintiff. If you're the defense counsel, you want it as narrow as possible. And there's a lot of back and forth, and I'm not sure often the benefit when you can simply say, you know what, issue your claim, grant me a reasonable waiver, let's get production of what we know we will have to produce. And at that point, we're not discussing in, theoretical issues, theoretical productions, we're discussing much more concrete terms. So to me, often the tolling agreement adds a step that sounds reasonable, sounds short, but often becomes unreasonable and anything but short, because there's a lot of back and forth that goes into it. And I can tell you, I'm embroiled in one right now, and it involves, for instance, jurisdiction. Right. So once you add more and more issues to it, the more and more complicated it is.
And for the same amount of time spent, you could probably have just issued the claim and served it.
That's my point. Thank you for summarizing my rant.
Awesome. If there's any other questions, feel free to ask them now. Otherwise, we can end today's presentation.
Well, before we end, I just want to thank Brendan for everything, including an excellent paper and his time, because as those who know me, anyone who spends more than a few minutes with me gets frustrated. So I appreciate his patience, indulgence, and kindness. So thank you.
Thank you. Man, that's unnecessary. It's so great to be invited. It was nice.
All right. Well, thank you everybody for attending today. I really appreciate it. I know it's the summer and there's probably other things you'd want to be doing. So thank you for coming for our hour-long presentation. Don't forget, before you sign off, you've got the certificate of attendance in the Zoom chat that you should download. Our next presentation is going to be in 2 weeks. It's going to be on discovery process for will challenges. So feel free to tune in for that. The link again should be in the Zoom to access that. Thank you all again. Have a great rest of your day.